let's get going. I think this is as good as it gets in terms of numbers. This session is everything foreign counsel might want to know about offshore litigation, but we're afraid to ask. And before I kick off, I just wanted to ask how many of you are foreign counsel for this purpose. That's to say, attorneys practicing other than in the offshore jurisdictions in this region. 1, 2, 3, excellent. Okay. This is doubtless why the organizers wanted me to do this talk alone. They were wanting to avoid the panel outnumbering the audience. So this talk is all about you, principally you three, or for you three. I'm going to spend the next 45 minutes telling you what I think you should know about offshore litigation and how to do it. And in return, you have 45 minutes to think of one question each. Is that a deal? Is that fair? All right, good. If you have more, then that's all fine too. So let me just posit this scenario for you. You're instructed by the general counsel of a US-based corporate client, which believes that it has been defrauded by an offshore company. It turns out, with a little bit of superficial investigation, that the company is listed on the Cayman Islands Stock Exchange. It has subsidiaries in the British Virgin Islands. It has bank accounts in the Isle of Man. And its majority shareholder appears to be a Jersey trust company. So where do you start? Now, this is not actually an uncommon scenario, not an uncommon structure, a perfectly legitimate structure for many businesses, many asset holding vehicles, many investment funds. But in cases where you have a fraud claim or other tortious claim, then it presents potentially a daunting challenge from the perspective of onshore practitioners. Pop quiz for you. Who coined the phrase "so near and yet so far"? Anyone? No? It's American, very famous. Mm-hmm. No? Close, but no. Actually, not very close at all. It was actually Cole Porter. He wrote that song in 1941 for a movie which is called "You'll Never Get Rich." Now, contrary to popular belief, that wasn't in fact a love song. He was actually writing it about offshore litigation. The reason why I say that is because for most of you as practitioners in a common law jurisdiction anywhere in the world, litigation in the offshore jurisdictions will look pretty familiar. We speak more or less the same legal language. We have the same legal or similar legal doctrines. But there are genuinely pitfalls for the unwary. There are traps for the uninitiated. And conversely, there are also some benefits to litigating in the offshore jurisdictions that may not be apparent to the naked eye. So I just wanted to give you a few things that I think you should always consider before initiating any litigation in any of the offshore jurisdictions. The jurisdictions that obviously that I am competent to speak on are the offshore financial centers in this part of the world and in the British dependent territories, although the same applies to other offshore jurisdictions elsewhere in the Caribbean. I think the first and most important thing is you need to understand the legal system that you are contemplating entering into. And I don't just mean understanding the laws or asking someone to advise you on the laws and the rules. I mean understanding the courts and the practitioners before those courts. Because almost all the factors that I will go on to talk about feed from an understanding of the courts and the practitioners in the courts. Because at the end of the day, you're bringing a case to succeed and to win, and you've got to understand the playing field that you're in. You've got to understand the players that you'll be deploying and the players that you'll be playing against. So when you look at these systems, look at these court systems, you've got to think about, is there a divide between different types of legal practice? Is there a divide between civil litigation and bankruptcy matters? Answer is no in most of the offshore jurisdictions, and that has an important ramification for your choice of remedies in pursuing claims. Does the jurisdiction have a specialist court or tribunal for the resolution of your claim? Some of the offshore financial centers now have commercial courts or a financial services division, as it's called in the Cayman Islands. Those are more expensive tribunals to appear in front of or to push your case through than in others, but it's almost always worth the price of admission. Those courts are staffed by specialist judges, usually taken from the ranks of the legal practitioners that appear before them, so they understand the industry, they understand the issues that are before them, and they understand above all the need for clients to get swift and efficient service. Let me just give you one example. I do a lot of fund dispute work, as you might imagine, being resident as I am in the Cayman Islands. So I'm involved in a case that was launched in the Financial Services Division in Grand Cayman in January this year, a fairly large dispute over a fairly contentious matter involving quite a lot of investors in this large Asian fund or Asian managed fund. The usual things happen after pleadings. There's an exchange of motions to dismiss and reverse summary judgment applications, and the usual interlocutory skirmishes start straight away. The judge calls everyone into his chambers for an impromptu case management conference or directions hearing. It says, I'm going to dismiss summarily all these applications. They're no good. It's not that they're no good, there's no point in them. I'm going to give advanced directions for trial. You won't need witness statements. I just want some discovery, exchange some skeleton arguments, understand what the legal issues are going to be. They're all going to be determined by the documents, and we're going to have a trial in June. And we are actually going to have a trial in June of a case that was started in January this year. This is not the first or the only time that I've been involved in cases that do that have seen this sort of expedition, and I've heard about it in other jurisdictions which have these courts and these judges as well. So it really is a tremendous boon to have that sort of facility. Another issue to think about when you're contemplating litigation in these courts is, actually, do you want to litigate or do you want to arbitrate? Do you have an arbitration clause that you want to enforce and to deploy, or do you have an arbitration clause that you want to avoid? Again, it's very important to know what the attitudes of the courts in these jurisdictions are towards arbitration clauses, towards arbitration generally. Do they have competent arbitrators on hand, on island, or not? Do they have modern UNCITRAL-styled arbitration laws, or not? Some do, some don't. There is a huge variety between the offshore jurisdictions in this respect. So the answers will be different depending on which jurisdiction you're looking at. And then finally, in terms of looking at your jurisdiction and its practitioners, what is the split between barristers and solicitors, attorneys? Is it a fused profession? Is it not a fused profession? How does it work? Because this will help determine the question that you need to answer to yourself is, well, what lawyers and what kind of lawyers do I need for the case that I'm going to bring? And conversely, what lawyers do I have to bring to the party myself using my own onshore counsel resources? Or do I need to bring in foreign counsel from, say, the London Bar, London QCs? So once you understand the system, then you're a lot better placed to start looking at the remedies that will lead you to the successful outcome that you're looking for. People talk a lot about strategic litigation, and what I think a lot of people don't really focus on very carefully is that it is the availability of remedies which will actually dictate your optimal legal strategies. You've got to start from what you can get from the court at the end before you can work out your strategy to get there. So just to give you some examples of things that you can get in the offshore courts that may not be apparent or may not be available elsewhere. The offshore courts, being based as they are on the common law heritage, derive a lot from the old courts of equity in England. Concepts such as equitable fraud and unconscionable behavior have led to remedies such as the ability to wind up companies for reasons other than bankruptcy, other than insolvency. So it is, for example, an extremely popular remedy, extremely useful remedy for all species of corporate divorce, when shareholders fall out with each other, whether they are minority shareholders in a venture, or investors in a hedge fund, or joint venturers who have had some terminal falling out. This is a remedy that is widely used to devastating effect when partners need to break off their corporate relationship. Another example that follows on from that is the availability of class remedies. Obviously, we don't have the same availability of class remedies, representative actions, class actions, securities litigation as you do in the US, the UK, and elsewhere in Europe. However, what we do see and use instead, again, is the winding up remedy to enable the class of investors or shareholders in a company to vest powers in a liquidator to go and pursue claims on behalf of that company in order to restore value to the estate, to bring assets back that have been lost, to achieve compensation from those who might be responsible, ultimately for distribution to the stakeholders in that company. So that's just an equivalent way in which the offshore jurisdictions deal with the notion of class remedies. Bear in mind also that litigation in the offshore world, just as much as the onshore world, is a two-stage process. You have your pre-judgment process and you have your post-judgment process. You need to think about the distinction between that between pre and post-judgment and the relief available pre and post-judgment when you're selecting your forum. Very often you have a choice of starting in the offshore jurisdiction or starting in the onshore jurisdiction and moving offshore with the benefit of a judgment. And there are cases where, in fact, you would be better off, for various reasons, to get your judgment onshore first, in your home jurisdiction, and then come to the offshore jurisdiction to get post-judgment relief in order to actually lock down and pursue and obtain the assets that would satisfy that judgment. And then finally, a very, very common feature of litigation in the offshore world that is probably used more often in the offshore world than anywhere else is the ex parte jurisdiction. That's to say the jurisdiction vested in courts to grant relief ex parte without the other side being there, without the defendant being notified or having an opportunity to make any representations or submissions or adduce evidence. This is extremely commonly used in the offshore world, much more and given much more license by the offshore courts than in England, where the concept came from, and indeed in the US, where equivalent relief is sometimes available, but much more sparingly. It's an extremely powerful remedy because, of course, it enables you to get ahead of time all kinds of relief against a defendant without them even knowing about it, to avoid tipping them off. But it comes with significant risks as well. Probably the most well-known price to pay for seeking relief ex parte is that you become under an obligation of what's called full and frank disclosure when you're facing a court on an ex parte application. This requires you to put all facts and matters and legal arguments, both good and bad, both for your case and against your case, in front of the judge when seeking that relief. And sometimes that burden is frankly very difficult to discharge, and there are cases where it's actually not worth the risk. There are cases where the best advice is you're better off waiting. You're better off having an inter partes hearing of your application rather than taking the risk of getting your relief ex parte and then having it overturned for some failure of disclosure, inadvertent or otherwise, and then the court is refusing to contemplate further relief on an inter partes basis. So getting ex parte relief is not always the be-all and end-all. It's not always the panacea for all your ills. So you understand the legal system, you understand the remedies that are available in the offshore courts, and as a result, you're starting to formulate a strategy that's going to get you the relief that you seek and ultimately the judgment you want or the assets that you're looking for. So this then turns you to the next phase, the third phase of your pre-litigation investigations into the relevant offshore jurisdiction, and that is looking for assets, and related to that, preserving those assets once you've found them. Now, this is probably one of the most misunderstood areas of litigation in the offshore world. There's a massive misconception about these jurisdictions as so-called secrecy jurisdictions, clouded in confidentiality statutes and similar, and also the attitude of the courts towards those that seek to pierce various corporate veils or to get relief or disclosure in relation to a defendant's assets ahead of judgment. In fact, if you track the evolution of jurisprudence in this area, it has been consistently led by the courts in the offshore jurisdictions for many years. The development of legal concepts that originally came from England have been picked up by various courts in the offshore world from Jersey to the BVI and have been developed way, way beyond what they were originally intended to achieve by the mother country. That is, I think, a fair illustration of the degree to which the courts in the offshore jurisdictions are, in fact, extremely keen to assist plaintiffs who have respectable fraud claims or similar claims against defendants in their jurisdictions. The courts have absolutely no interest in protecting such parties. So, what have we seen by way of evolution of those remedies? I think the first thing that's of note is the discovery remedies that you have available to you as a putative plaintiff in the offshore courts. There's a relief known as Norwich Pharmacal Relief, which is a form of discovery order that you can obtain against third parties, usually accompanied by a gagging order to avoid the third parties from tipping off your defendant. This was relief originally intended to enable a plaintiff to obtain from a third party who had innocently become mixed up in a fraudster's or other wrongdoer's conduct in order to assist the court by identifying the wrongdoer in question to enable a claim to be brought, a substantive claim to be brought against that wrongdoer. Since then, though, since that jurisdiction was originally created by an English decision, hence the name Norwich Pharmacal, which is the name of the case, it's been expanded quite considerably by the offshore courts in the Isle of Man, Jersey, BVI, and the Cayman Islands in particular. So that now the relief you can get by way of Norwich Pharmacal Relief, third-party discovery, includes not only getting assistance in identifying the relevant wrongdoer, but also the very cause of action that you might have against that wrongdoer, and indeed the assets that that wrongdoer might have or might have parked with the relevant third party. So it really has become an extremely broad and wide-ranging remedy available to get early third-party discovery to enable you effectively to perfect your claim before you've even started, and to do so within the confines of a gagging order to enable you to analyze the evidence that the third party discloses and to bring your claim, or of course, if it turns out you were barking up the wrong tree, not to bring your claim and leave the defendant none the wiser. Another area where discovery orders have been expanded in their use in the offshore world is in aid of execution of judgment debts. That's to say, if you have obtained your judgment against your defendant in your onshore jurisdiction, you wish to execute that offshore, you think there may be assets, but you're not sure, you're not certain, you may be able to get Norwich Pharmacal Relief against a custodian or a banker or a trustee or a registered office service provider who can provide the information if you have sufficient evidence to suggest that they have that information about the existence and extent of those assets for the purpose of executing on that judgment. That is an extremely common remedy in the offshore world now. As I said, something that wasn't, I think, originally within the contemplation of the English courts when the jurisdiction was invented, but now it is a routinely granted remedy. Another area where you may obtain disclosure is as an ancillary order to support a freezing order. I'll come on to talk a bit more about freezing orders, asset freezing orders, but the so-called Morava injunction, as it was originally called, now relabeled asset freezing orders in modern nomenclature. Again, an invention of the English courts. Again, a jurisdiction that's been taken up and applied with gusto by the courts in the offshore world to achieve the ends of justice for plaintiffs who wish to lock down assets before they have the opportunity to execute on them by way of a judgment. As you could imagine, it's an extremely commonly deployed remedy where you have assets held by custodians, where they're held by banks or trustees, or controlled by corporate officers in remotely administered corporate services arrangements. It's one of the ironic advantages for a plaintiff in pursuing fraudsters that have chosen to use the jurisdictions in the offshore world, that because of the very onerous KYC requirements that service providers have in these jurisdictions, whether they're corporate administrators or bankers or trustees or other, they actually hold an absolute minefield of information about your defendant, about your defendant's business, about his activities, its movement of assets, location of funds, so that if you can show a case, you can get far more disclosure about your fraudster in the offshore world than you could if you're simply suing that fraudster in the onshore world. As far as asset freezing orders are concerned, again, there's been a significant evolution about asset freezing orders, principally in the British Virgin Islands of note in recent years. There's a case called Black Swan, which has now, I think, achieved some notoriety. But the commercial court in the British Virgin Islands, in the form of Mr. Justice Bannister, decided to grant for the first time freezing order relief in support of a foreign proceeding. So this now gives you an alternative option when you're contemplating your litigation strategy. And I said earlier, you may be in some cases better off suing in your home jurisdiction or defendant's home jurisdiction rather than in the offshore jurisdiction where the assets might be. Well, the Black Swan doctrine or Black Swan principle enables you, certainly in the British Virgin Islands and other jurisdictions which will follow and are already following this doctrine, to do just that. Essentially, you go to the court and you say, well, I'm bringing my substantive proceeding over here, but I'd like you please to freeze the assets of the defendant in your jurisdiction here, pending the outcome of the substantive primary litigation. So it doesn't force you to litigate in the offshore jurisdiction, it simply holds the assets while you are suing and litigating elsewhere. Now, I should say that that is a doctrine that is somewhat controversial in offshore legal circles. The courts of the Cayman Islands have rejected that doctrine. They say it doesn't work as a matter of legal analysis, but it is widely followed in other areas of the Caribbean. So Cayman is a bit of a holdout as far as that particular doctrine is concerned. My own view is that it will be amended in the Cayman Islands by statute in short order, so you will effectively be able to get the same kind of relief as is currently available in the BVI. Cayman has led the way, on the other hand, in relation to another form of freezing order relief known as Chabra relief. This is another very useful tactic that you can deploy in the context of freezing orders, which is to freeze the assets of third parties against which you have no substantive cause of action. Normally, of course, you have to have a cause of action of some kind or another against your defendant, even if you're not going to be pursuing it, even if you're going to be pursuing that cause of action in another court in order to get black swan relief. But you can, in certain circumstances, obtain asset freezing relief against a defendant against whom you actually have no cause of action. And that is the so-called Chabra doctrine, in cases where you can satisfy the court that the third party, or the non-cause of action defendant, has assets which, for one reason or another, should be made available to meet any judgment that you might obtain against the substantive defendant, the real defendant. This was most recently expounded in a case in the Cayman Islands called Al-Ghasaibi and Al-Sanea. It's a long-running piece of litigation between two very wealthy Saudi billionaire families, in which the claim that was brought by the plaintiff was against the defendant, an individual defendant who was resident in Saudi Arabia, and some 40 companies of his in the Cayman Islands. Some of those companies evidently did nothing wrong. There was no cause of action the plaintiff had against them. But on the other hand, they did hold very valuable assets within the business empire of the primary defendant. And as a result of that, the court was prepared to grant asset freezing relief against those defendants, even though there was no cause of action against them, for the purpose of satisfying any judgment that might be obtained against the primary defendant. So with these sorts of reliefs available to you, it does open up significantly your options and alternatives when you're considering where to litigate first, where to litigate second, that's to say pre-judgment and post-judgment, and how to do as much as you can to preserve the assets that you know exist or have found to exist in the offshore jurisdictions in which you've sought the relevant orders. One other form of relief that's very handy and again has been developed quite significantly by offshore courts is receivership orders. And in particular, receivership orders in aid of execution of judgments. Again, this is an example of why it's quite handy to sometimes start off with a judgment obtained in the onshore courts before coming offshore. There was a case called TMSF and Demerel that went actually to the Privy Council, which is the highest court of appeal for the courts in the offshore world, the Cayman Islands and elsewhere. And that was a case in which a massive fraud was perpetrated by the nephew of the former premier of Turkey against some banks, which became insolvent, and then pursuant to the banking legislation in Turkey, were passed under the control of TMSF, which is essentially the Turkish equivalent of the FDIC, which brought these proceedings against Mr. Demerel. They obtained a multi-million-dollar judgment against him in Turkey, and then sought to enforce that against him in the Cayman Islands, because they had discovered that there was a trust that he had set up. He was the settlor of a trust that was set up in the Cayman Islands with a Cayman Islands trustee, a local bank. This was a revocable trust, and so there was considerable concern that once the proceedings were issued, that he might revoke the trust and allow the assets to revert back to him and thereby be immune from execution through the Cayman courts. So the relief that we obtained on behalf of TMSF was somewhat novel at the time, and as I say, it took the Privy Council to agree that this even existed as a jurisdiction. But TMSF obtained a receivership order. They appointed a receiver over the power to revoke the trust. So essentially what that meant was that the settlor, the original settlor, was disabled from revoking the trust and allowing the assets to revert back to him for personal use. It's another, as I say, another example of the offshore courts, albeit with the assistance of the Privy Council in this case, developing these doctrines in order to achieve justice and to prevent assets which were plainly should have been available for enforcement and execution of a judgment from being whistled away by a determined and recalcitrant fraudster, as Mr. Demerel had been found to be. So those are some examples of the weapons that are available for offshore litigation in terms of hunting down assets and preserving those that you find. A couple of additional points just to bear in mind, I think. One obviously is costs, a subject dear to all of our hearts and especially those of our clients. Most of the courts in the offshore world apply a loser pays principle. This is something that will be familiar to all those with an English or English-based legal background, but less so elsewhere. And there is obviously a slight gloss on that, where you have cases that are using a winding up remedy, then the costs are not paid by the loser so much, they're paid by the company that you put into liquidation, assuming it has assets. A corollary to the loser pays doctrine to bear in mind if you're a plaintiff is that there is a jurisdiction in almost all the offshore courts which allow for a defendant to obtain security for costs, security for its costs for defending the claim. Bear in mind that you may be asked as a plaintiff or your client may be asked as a plaintiff to put up substantial security for the defendant's costs of defending the proceedings, even if that defendant is the subject of a fraud claim. So there is a significant investment in litigation in these courts when you're bringing that sort of claim. Thirdly, there are in each of these offshore jurisdictions quite differing rules about the assessment process whereby the loser pays jurisdiction is actually worked out. It's known as a process of taxation, which is always, I think, an ironic description of this process for jurisdictions which actually have no real taxation. But anyway, there it is. And to varying degrees, there are quite significant restrictions in the taxation rules of these offshore courts about what costs may be recovered at the end of the litigation. In particular, the costs of foreign counsel and meaning in instructing attorneys, US attorneys, English solicitors, and sometimes Queen's Counsel, barristers who are brought in for particular parts of the case, may not be recoverable unless certain procedural steps are taken and the court has essentially approved them in advance. I think the upshot of that is that you need to plan up front the work split between your team, the onshore legal team, and the offshore legal team before you even start work, and to think about what's the most efficient way to split that work and what's the most efficient way to get as much of that work recoverable if you succeed at the end of the day. Talking of splitting work and dividing labor between onshore and offshore, the final thing I wanted to mention was the selection of counsel. Obviously, a lot of what I've said probably implies already that a lot of offshore litigation is won or lost by means of what's certainly known in the United States as motion practice. A lot of early interlocutory applications that are brought either to freeze assets, to get disclosure, to get security for costs, and so on, often will result in putting you in a winning position versus a losing position. But in order to be able to execute on those strategies, you need to be using and working with offshore counsel who can act quickly and decisively as plaintiffs, or indeed can respond similarly when they're on the receiving end of such applications. You cannot assume when you go into the offshore world that there will be the same depth of bench and capability as you may be used to in the onshore world, in the firm that you work with or the bar that you work in terms of the caliber of people, in terms of the quality, in terms of their availability and experience and so on. You just can't take that for granted. Different firms deal with this problem in different ways. So, for example, quite a lot of small firms will bring in London counsel to help them on matters large and small. This can obviously add significantly to your capability and your resources, your expertise, and the quality of the advocacy that is going to be put forward on behalf of your clients. But on the other hand, it may have a significant impact in terms of costs and delays in terms of getting the counsel out for the hearing, availability, and so on. So you just got to bear that in mind. Increasingly, the offshore firms around the jurisdictions which do a lot of this kind of work have started to actually employ QCs within their ranks, partly to ameliorate this problem and to provide effectively an in-house advocacy capability. But that said, most firms have one or perhaps two throughout their entire organization, and there'll be a lot of demands on their time, so they may not always be available. The general point that I would make about the selection of counsel for litigation in the offshore world is you must book early to avoid disappointment. Because even if you think this is a two-party case, plaintiff and a defendant, and I say the example is that we're talking about is a fraud case, there are always more than two parties in that kind of case. And some of those parties are actually already being represented and advised by the firms that you might want to instruct, whether they are acting for the bank, the custodian, the trustee, etc. You don't yet know, and you won't know until you actually launch your proceedings, who else is going to come out of the woodwork in a lot of these cases. So, as I say, book early to avoid disappointment, or you may find yourself going through the phone directory and finding yourself on the last page looking for somebody who can help you, and you are already at a significant disadvantage at that point. So, as I said, these are some of the things that struck me as being of, I think, key importance when you're contemplating bringing proceedings. Once you've ticked off these particular considerations, there may be others for individual cases. You may have had your own experiences, good or bad, and you may have some insights of your own or some questions to ask about them. So I want to turn it over to you guys and let me know if there are any particular topics or issues that you've encountered that you'd like me to respond to. Ed. Mm-hmm.
It hasn't historically been the case in every jurisdiction. And if you find if you don't know, there's a risk that you're going to get either not complete preparation or no preparation at all. And it's very disappointing. And if you just stay in your home country and get a home report of how the hearing went, you're not likely to get a true, very candid, an accurate representation of how the hearing went. And you'd be surprised how many times courts allow for a adjournment when foreign counsel doesn't come, when the instructing counsel doesn't come. It's much harder for the lawyer to consent to or even ask for an adjournment or for a judge to do it when you're sitting there and they introduce you to someone flown in from London or from New York or from Miami or wherever. And so I personally think it's important to go there and be there if you're instructing counsel in the Caribbean. Now again, I don't mean to apply that to every firm is an issue, but it's certainly something to keep in mind. And look, if the other side, it's very common in the Caribbean for them to walk into court that day and say, "May I have adjournment?" And they give it to you. And you're stunned because you've flown in a team, you spent $20,000, $30,000, $40,000, you're ready to go, and the adjournment is granted under the flimsiest of excuses. And that's not something that would occur, at least for an American lawyer. Most of the time, when you're told to be at a hearing, you better, someone's arm better be lying on the floor, and an amputation or some traffic accident that's serious before a judge will roll over a hearing. So, to me, the one thing to take away is that you've got to be involved and be there, physically.
No, that's absolutely right. And in fact, I'll tell you this, that increasingly, a significant phenomenon I have witnessed in the last few years here has been senior partners from major law firms both in the US and the UK coming to the Cayman Islands to kick the tires of all the law firms with whom they have worked over the years. These are firms that are constantly litigating or have clients who have litigation issues in the offshore Caribbean world. And they know us pretty well. They know all of us pretty well. But still, despite that, they are coming to physically check us out, to eyeball us, to say, I want to meet some of the new people in your team. I've heard so-and-so's left. Who have you replaced them with? Is this person any good? Who else have you got? How are you evolving? What are you saying? And we're getting beauty praise without even getting any prize at the end of it, right? They're coming down to investigate us and to keep tabs on what we're doing, rather than just reading our self-promotional literature that we're also good at, or our marketing departments are also good at putting out on our behalf. We all do it to varying degrees of success, and you're absolutely right, Ed, that there is no substitute when you're selecting counsel for coming down and actually doing a real test of what they're capable of achieving. And in the process, as Ed says, learning a bit about the culture, and this comes back to one of the points I made about learning about the courts and the process and the practitioners, things like adjournments. Now, I actually had an experience that went the other way, where I was advising a client, a large client locally, that had some litigation issues in Canada, in a province of Canada. I hope there are no Canadians here to insult. Oops. Anyway, too late. And unbeknownst to us, there was a practice in this particular court of agreeing adjournments of hearings with the other side without taking instructions, without asking the client for instructions first. Complete anathema to me. I mean, my client was absolutely appalled. I'd never heard of anything like this. We'd done a lot of litigation together. Anytime I'd had an opponent ask me for an adjournment, I'd ask my client, and we'd discuss it and decide and then respond. But in this case, we just got a notification that the hearing had been adjourned, and I called the actually very eminent, very senior lawyer in this very eminent Canadian firm and said, what happened? Why? He said, well, I owed him one from another case. So we have this tradition at our bar, in our bar here, that he needed a bit more time, so I gave it to him. Okay, so we fired that firm and went with another firm. But, that is the experience that you can have anywhere. So you've got to know your jurisdiction. You've got to know how they operate in practice. You're absolutely right. Sorry, Felicity.
I was going to make another point and then ask a cheeky question. The point I was going to make was that the other thing about knowing your jurisdiction, there are some jurisdictions which are very, very, very favourable to home litigants, and I don't necessarily know lawyers who are home litigants. So in my field of cross-border bankruptcy, if you have a local insolvency practitioner, there are often cases where they would do stuff that would, in my jurisdiction in England, be outrageous. But because they're a local guy, this is how it is, it's always done this way, and whatever they say is law. So that, I think, was the biggest surprise to me, that things that were egregious in my mind are just kind of waved through because he's the local guy. So that's important to know when you're giving advice on what to do. And that's where having offshore law firms involved is obviously vital. So my cheeky question was, are there any offshore jurisdictions where you would advise clients not to think about litigating? And I don't mean because of the forces of action, I mean because of infrastructure or judge quality. I won't say lawyer quality, but are there any places which are just so haphazard still that you would advise not to litigate?
Plenty. If I can put it this way, if you look at all the jurisdictions where all the leading offshore firms have spent the last decade or two opening offices, if they haven't got an office there, or there isn't a firm there that's in more than one of the offshore jurisdictions, if it doesn't call itself a financial services center or something similar, then you don't really want to litigate there. If you're litigating there, it's because you have to, because you bought a property there, or you didn't realize that the asset trail would lead there, whether it's the Marshall Islands, Vanuatu, Nauru. Those are places where there's almost no point. And there are jurisdictions nearer to home. There are other jurisdictions in the Caribbean where we have quite a lot of calls coming into certainly our BVI office, for example, because of its physical location in the Caribbean, saying, can you name us, give us a lawyer that's competent, or give us help in relation to one of these jurisdictions nearby. And we hear absolute horror stories, and actually they are principally not about the lawyers, but they're principally about the judge, not the judges even, but the system, the process, and the time that it takes to get things done. And so I wouldn't even give you a short list of half a dozen, it's too many. Coming back to your point about home litigants' advantage, you're absolutely right in identifying one particular area, and I know there are a couple of representatives here, so I know they won't take it personally, but insolvency practitioners, court-appointed individuals, office holders as liquidators or receivers, bankruptcy trustees or equivalent, do get the rub of the green. There's absolutely no doubt about that. That's one of the reasons why I was saying one of the remedies that is much favored in litigation or potential litigation on behalf of a plaintiff of varying kinds is to get a liquidator or other office holder appointed, because they do get the rub of the green. They basically are uber litigators. They're given enormous powers to investigate and litigate both locally and then abroad if they get recognition under the widely available cross-border insolvency processes that you will find available to them. That's not to say it's unfair necessarily, but that's just the way the system is set up. They're set up as office holders, so it's expected that they will discharge that duty honorably. And by and large, they will do. But you're absolutely right. There are a couple of occasions where they'll push the edge of the envelope, and they'll say, if pressed, well, I'm not doing it on my own behalf. It's no skin off my nose. I'm doing it on behalf of my constituents, my stakeholders. I'm trying to benefit the estate. And there is no doubt have been instances of overzealous applications or litigation generally by office holders, and sometimes they've been called to task on it. But you're absolutely right. If you are a defendant or potential defendant or representing a defendant facing an office holder, then you've got to be aware that you're facing a very powerful adversary who will get the benefit of the doubt, and legitimately so a lot of the time. You don't mind me saying that, Paul, do you? Yes.
I have a very significant judgment from the states against a UK citizen who's in jail in the UK. And we did some post-judgment discovery and found some wires of significant amounts of money that went to the UK, that went to BVI. We have some information that the Isle of Man has some investments that this person had. And I talked to a solicitor in the UK, and he acted like it would be extremely difficult to domesticate that judgment and begin collection activities over there. And I guess my question is, each of those places are different jurisdictions. So you've got the UK, you've got BVI, you've got the Isle of Man. Are they similar in how you enforce a judgment, or how you, I need to do some more discovery, I need to do some more investigation into the assets? And are they similar in the way that you do that?
Well, as far as enforcement is concerned, I guess I should say as a preliminary point, it sounds as though the UK lawyer you were talking about hadn't been to my presentation that I did last year on the same subject, because clearly that person doesn't understand the offshore legal systems that you've asked him about. I'm afraid you're probably talking to the wrong lawyer. There are lots of UK lawyers. There are lots of UK lawyers that do know enough about litigating in BVI, Isle of Man, and elsewhere that can give you a decent answer. And if you still can't get it, get my card afterwards. But as far as enforcement of a judgment is concerned, there are really two ways of doing it, and some jurisdictions are more modern than others. The old-fashioned way of doing it, that is a default way, if you like, of doing it, it's imperfect but not bad, is simply to sue on the judgment debt. In the relevant jurisdiction, you get summary judgment based on the judgment debt that you've already obtained. So it's not as quick as the registration system, but it works okay, and you can get freezing relief and collateral discovery and so on to support that. But in many offshore jurisdictions now, you can get automatic registration of judgments. and it can be therefore done as an administrative process very, very rapidly.
Can I ask a question? Is it a default judgment, or was it following a trial in which you admitted?
It was a default judgment, but there was an extensive hearing on proving up the judgment. So, I mean, yes, it was a default.
It sounds as if it was an uncontested judgment as opposed to default. Default has a specific meaning in legal terminology, which basically means that effectively the defendant failed to respond or failed to acknowledge service, failed to file defense, and as a result, you can enter default judgment as an administrative process. You don't normally then have to do any proving. So.
There was some extensive, the judge wanted some extensive proof because of the amount of judgment we were seeking on the damages, but it was a default in that he did not appear, after he was.
Right. The reason why Felicity asked that question is it can have an impact on your ability to enforce a default judgment elsewhere, depending on the conflicts of laws principles applied by the relevant jurisdictions. It's quite difficult to enforce a default judgment by way of summary judgment elsewhere. Yes, Ed. Absolutely, yeah.
Going back to tips for instructing as well for counsel. The other, I played 15 years, almost 20 years of instructing accounting and recruiting. I have yet, save one experience, ever felt that I had a corrupt judge. So the sort of mythology that there's a lot of corrupt judges in recruiting, and frankly, I don't buy it. I haven't seen it. Right? I've seen a lot of judges that struggle because they're under-resourced, but I haven't seen it. I've seen one case where I believe we had a corrupt judge. But where you can get in trouble, and where I think a good local counsel helps is, I think there are a lot of corrupt registrars. And the registrar is something that we in the States don't think about. Because we have court clerks and they just do things on an automatic basis. But a registrar in the Caribbean is a very, very powerful person who is usually a lawyer, and he basically controls your ability to get on the court's docket. And that's the other. And then lots of times you can tell you're walking uphill because the other side's getting hearings when they want them, and they're not getting hearings when you want them. Well, all of a sudden you're hearing delisted. It's literally delisted. You have no idea why it's not on the docket. So to me, one of the tips is you've got to find someone who's got juice with the registrar to make sure that that's not happening to you. Because that's an easy way to get behind the 8 ball in the Caribbean if you don't have that level of attention on that. This may not be an issue in Cayman, but I can assure you it is an issue in some of the smaller other islands. It's a tip for Americans to assume the clerk of the court is going to just, put everything as they come in, and that everything happens normally like it does in most American jurisdictions. It doesn't happen like that at all.
Yeah.
So, that's one tip I would give is watch out for the registrar. They can be bought off, in my opinion.
Even without that, in a lot of the Caribbean jurisdictions, the court registrar struggles under an enormous administrative burden. A lot of courts do the full range of financial services, big ticket commercial litigation through to matrimonial and criminal stuff, and everything comes in through a single registrar that has to list everything in front of 1 or 2 judges who may disappear on vacation or go off island to a conference like this, and then all of a sudden their judicial resources are halved for a week or 2. And they really, really struggle, and you can get some very patchy outcomes of patchy results in terms of listing hearings and moving your case forward. One of the things, for example, that was done in the Cayman Islands, and I know other courts in other offshore financial centers are doing similarly, is to adopt more of a US docket-style system in the financial services division for the big-ticket commercial litigation that is handled. So what you end up with is a completely separate track for that kind of litigation, so you don't have to barge in the queue with other kinds of litigation that have a different pattern to them and a different lifespan. And in addition, you are listing your hearings. Once you have an assigned judge who is assigned to your case, your hearings are listed by direct correspondence with the judge's secretary. So you're not going through the registrar at all anymore. You're not going through the central court system. You're going straight to the judge's secretary, whose diary or the judge's diary is pretty much an open book. So everybody knows when that judge is available, when they're not. And it's very, very easy, therefore, to list hearings. And you don't end up with the perception that you're not getting equally treated in terms of moving your case forward and getting your applications on or your hearings before the judge.
Except if you have an assigned judge who's assigned to all the big cases, he's then more available and you can't go to any other judge because
There is actually, it's a fair point, and there is now a procedure to move an over-assigned judge to or off the case, or to get somebody else to come in for a temporary thing. Chris, hi.
The last 15 years, the immense problem through the European regulations has been proposals, or there's been actual legislation authorizing communication between judges, trying to communicate and coordinate. Has that actually happened at all in the European? I know now the European regulations are actually proposing mandatory discussions. I know at Onshore now we're addressing the same thing, but do you see any of that change at all? Because one of the problems I see in a lot of litigation is failure of courts to communicate. The liquidators sometimes go off on their tangents without really paying attention to what's really in interest of growth.
Yeah, you're absolutely right. It is an important point. It's more than on the radar, it's on the list. But I don't see it yet coming into force by way of formal statutory change, rules change. Some of the judges, and again, speaking really from experience, one case in particular, the BCCI liquidation in Cayman, that is, for those that don't know, after some 21 years, has now finally come to an end just last month, which is pretty extraordinary. It's the largest and longest lasting liquidation of any corporate enterprise anywhere ever. And in that case, there were a number of estates being liquidated. One of them was a Cayman operation, one was Luxembourg, one was England. But in that case, there were no formal protocols in place, and this started out in 1991. There were no formal protocols in place between those jurisdictions, and the judges just made it up as they went along, with the assistance of counsel, and it was done in a very, very collegiate and cooperative way. You had the judge running that case, who's now our Chief Justice, picking up the phone, first sending a fax over to his counterpart, and then picking up the phone and having conference calls, and three-way conference calls sometimes, in order to resolve issues and difficulties that arose. That experience led to various practice directions coming out saying, we've set this precedent, and we're going to do this in other cases, so feel free to use that resource. And since then, judges have carried on, in my experience, certainly in the Cayman Islands, using that sort of approach. But so it has the advantage of being very informal and very flexible. The disadvantage is that it's somewhat uncertain. And for new litigants or new parties to the game, they feel some understandable skepticism about whether and how that process will work. And so I agree it would be a good thing to formalize it. And obviously, the template is there, just requires signature now. So hopefully that will be soon.
I'm slightly less optimistic about it, because I think one of the things that happens is judges are very happy to listen, but they don't have anything to do. So BCCI was the kind of no-brainer because we had a pooling agreement. And so once you knew you were dealing with something that was pooled or a substantial consolidation type thing, then it was completely open in all these jurisdictions to say, oh, well, these office holders, it doesn't matter where you are, everybody's happy, we're one big happy family, apart from Luxembourg.
That's good.
Less like a happy family. But in a lot of other cases, I've been on calls where US and UK judges have talked to one another, and UK judges say at the end of it, well, that was all very interesting, but that's not how we do it in England. And so even if you get an assigned judge, it's not in our genes, this kind of cooperation. And it's fine when you're all pushing in the same direction, but when you're putting in other directions, English judges don't like it. And some Caribbean judges feel the same way. They think, well, don't come and roll over me because I'm in the Caribbean. I have my own views. So it's a great theory, but the problem is when it's pushing in other directions.
The use of protocols, I think, has become more prolific in the last 10 years. And in many situations where you have protocols, the courts actually have to review it. And so they don't have direct communication, but they have input as part of the process. And protocols, in a lot of situations, help the different jurisdictions
That's
Right.
where it works.
Yeah.
Where the office holders go together and say, this is what we've agreed, and go to court, like perfectly sense legally. Where the English court gave a judgment which said, I'm so delighted, you guys are fabulous, I'm so pleased that you've come to an agreement. And of course, I'm not saying anything about whether the agreement is good or not, but it's fabulous that you've done it. Whereas if they were fighting about it, the English court would have agreed with that. So,
Yeah.
In fraud cases, if the different entities cooperate is one issue. Like Stanford was a classic example of total lack of cooperation.
Yeah.
Because-
although not now. Now it's.
No, that's not great.
You'll continue always to have a level of competition between estates in the offshore and the onshore courts where you've got a multi-jurisdictional insolvency of one kind or another, especially if one of the office holders, usually the U.S. office holder, is appointed pursuant to some regulatory activity or enforcement effort, comes from it with a slightly different perspective. In particular, the perspective of what assets fall within the onshore estate. And you quite often get lists of assets. Say, well, I'm an SEC receiver over all of this. It happens to include a couple of BVI companies and a Bermuda company and so on. And you kind of wonder how that got sucked in. And then, then what happens is the court in the BVI, Bermuda, or wherever, then has to work to protect the constituents, the stakeholders of that entity. And then you end up with the courts at loggerheads in that kind of scenario. And that is always going to be an issue, and no amount of protocols or indeed legislation or rules will really deal with that problem.
Yeah, the thing that's changed substantially is Onshore just finished a provision that got enacted on Cayman, providing Cayman with some principal issues. European regulation goes through the same process, so it may be that Cayman gets better defined, may provide more predictability throughout the process.
Yeah.
Adoption has been one main issue of Cayman with the U.S. on Chapter 15, what to expect.
Yeah. Well, Chapter 15 is now, again, an available resource for offshore practitioners, thanks to Ken Chris, who I think is in the next room, on Fairfield. Obviously, a lot of people are now a lot more confident about getting Chapter 15 relief, and we now know that you can manipulate COMI legitimately, and we're all a lot happier about that.
Yeah, but the trouble is that Onshore has changed that because they determined that the time of determination of only should be as of the date of the original.
So basically, that's
opening of proceedings.
the Gropper view from Millennium. Yeah, that was the right decision. Always the right decision.
One last thing. You have to be careful as a U.S. practitioner, over promising your client, the U.S. client, about what's going to happen in Prevail and instructing counsel, because A, it's not a hearing. B, once you get a hearing, you might not get a reasoned opinion for 6 or 8 or 9 months. I know that the courts have tried very hard to do better on that, but these are judges without law clerks. They don't have the law that our federal judges do. They have to write everything themselves. So sometimes I learned the hard way that you better not overpromise, so you better be very careful with caveat what you tell your clients. Because you might, and especially with the strategy together, you better be thinking about months, not weeks, before you get results. It takes a long time, and costs can be, as listening to the door. So when you bring QC in, your costs go up geometrically.
I'm very cheap. And I'll do it by video.
You heard it, that's on tape.
Excellent. No, you're absolutely right about that, and of course, it's the one thing that we can't control is the time for delivery of judgments. It's something that the practitioners in a number of the offshore jurisdictions are now working on, and increasingly, I think the judges, to be fair to them, especially those who have been appointed from the ranks of the practitioners who are now doing the advocacy, former senior partners of the law firms and so on, they get that, they understand that it is part of the service that we provide is the delivery of judgments. It's no good just litigating up to the point of a hearing and being done with it. And so they are beginning to change their ways, and they are beginning to feel more accountable to their consumers, the customers, in terms of delivering reasoned decisions. Well, thank you all very much for attending. Thank you for all your helpful, insightful questions and comments.